All right, so 1692E, 15 USC 1692E. I think I covered it briefly on a podcast, but we're really going to talk about, as far as disputing a speeding ticket. I gave enough information to start on the podcast, but like I said, the class is for deeper things I cannot talk about in public on a podcast. Oh, the podcast is about to go live actually in like 6 minutes. Make sure y'all tune into the New Cap podcast when y'all get off this class. I interviewed my friend Precious Price. She's talking about Airbnb, and she's gonna really help y'all get started in Airbnb. But that's besides the point. 15 USC 1692E, false or misleading representations. Let's get straight to it. A debt collector may not use any false, deceptive, or misleading representation or means in connection with the collection of any debt. Without limiting the general application of the foregoing, the following conduct is a violation of this section. So number one, the false representation or implication that the debt collector is vouched for, bonded by, or affiliated with the United States or any state, including the use of any badge. Does a police officer have a badge? Congress told you police officers are what? Debt collectors, right? So you can get them under this violation if they attempt to collect a debt from you, meaning a speeding ticket. So number two, this is a violation too. This is one of my favorites as well. The false representation of the character, amount, or legal status of any debt. What's my favorite one over here? Amount. If they send you a letter and they say minimum payment, whatever, it could be $1. That's a violation. False representation, because a debt is alleged obligation. They're giving you something that is allegedly yours, right? So that's a violation right there. Remember, each violation is $1,000. We've been here talking about it, maybe like 30, 40 minutes talking about it. We haven't even been through all the sections, and we've already found thousands of dollars of violations. So really just understand that, these violations are there. So if they say you owe any amount, that's a violation right there. 3, the false representation or implication that any individual is an attorney or that any communication is from an attorney. What does that mean? An attorney cannot communicate with you. You as a consumer are very, very powerful. So if you get a letter from an attorney, that's an exhibit. That's a violation. I'm pretty sure they understand that. But to be honest, most people don't know the information that we know. Those of y'all that's in this class, you obviously know a little bit about consumer law, at least a little bit about consumer law. And I'm pretty sure you know more than most people know about consumer law. So these attorneys, judges, everybody, they just assume that everybody doesn't, know this information. People don't know their rights and things like that. And it's sad that's the case, but that's why, at CAT, Consumer Ammunition Tactics, it's our duty to make sure y'all know this information in a digestible way. Because when I first started, learning these laws and things like that, it wasn't as digestible. So when I was learning it, I was like, okay, I know I have to pass this forward. So let me make it in a more digestible way. That's where you get the podcast. That's where you get these master classes. You know what I'm saying? So yeah, that's just a little bit on the goal. So number 4, the representation or implication that non-payment of any debt will result in the arrest or imprisonment of any person, or the seizure, garnishment, attachment, or sale of any property or wages of any person, unless such action is lawful and the debt collector or creditor intends to take such action. So it basically says that they can't threaten you to say that if you don't pay the debt, they're gonna close your account. They can't say that it's gonna result in arrest and things like that. That's a violation. That's $1,000 violation, at least $1,000, right? They can't garnish your wages, things like that. So yeah, just really understand that they're committing a lot of fraud, a lot of violations, and people are just allowing them because they don't have access to the information. Number 5, the threats to take any action that cannot legally be taken or that is not intended to be taken. So they can't threaten to do something that they can't do. And I'm going to give y'all a law that I never spoke about on a podcast or anything that lets you know that corporations, debt collectors, they can't sue you. Right. So pay attention later when I give it to you. You can combine it with, this number 5, and you'll have a powerful dispute. The false representation or implication that a sale, referral, or other transfer of any interest in a debt shall cause a consumer to lose any claim or default. I wouldn't focus too much on that. So just understand it's a lot. If you really go through all of these, for the sake of time, I'm not going to go through everything, but some of these are redundant to previous sections. So if you spend your time going through all of it, you'll really realize that you can get a lot of violations. Look at number 10, the use of any false representation or deceptive means to collect or attempt to collect any debt. attempting to collect a debt. That's a violation. That's already $1,000 extra over there, right? So yeah, just really understand it goes real deep. It goes all the way to number 16. But yeah, we're going to continue if nobody has any questions on 1692E. And then remember, 1692E is where your foundation for disputing a speeding ticket is. And when I say disputing a speeding ticket, I'm not telling y'all to drive 100 miles per hour, you know, just to test it out or anything. So drive safely. But if you do get a speeding ticket, there is a way because the law. So any questions? I do not condone speeding. Drive safely, drive carefully. But if you got a speeding ticket, there's a way.